and welcome to Beyond the Pale. That's not what I need to look like. I should be in the centre there. So bear with me. Let's just do it. There we go. I'm in a circle. I don't know why, but let's see. No, we're going to have to stick with that. So hi, welcome to Beyond the Pale. I'm not sure if anyone's around because it's Easter, but happy Easter. It's been a long time since I've seen you guys. So I thought today I would go through a very important video that I have discovered by the NACDL. That is the National Association, NAC, Community of Defence Lawyers, something like that. I did a lot of research into why an innocent person might take a plea deal. So if you're like me, and if you know me, you'll know that one of the last videos I did was right as Kohberger took a plea. Hi, Justice. Right as Kohberger took a plea deal. And I jumped on that train of thought where, well, he must have done it then. What sort of person, after all this time and fighting in all the small mini trials, I suppose, all the courtroom drama we'd come across, or sometimes not any drama. Anyway, after months and months and months of thinking this was going to trial, plea deal. And I thought, well, he must have done it. And then I kind of left it for a while and I started watching all of the information that was coming out. Thank you to Jules of All Trade and Lana and anyone else who's been really working hard to get us the information with the FOIAs. And I followed it all. And I'm back thinking, this is just my opinion, that this guy is the least likely suspect out of everything I'm seeing. None of my questions have been answered. In fact, things have just got worse and worse. So how are you, Justice? You okay? I can't even remember how to there we go. I think we're going to be quiet tonight. It's Easter, but I thought if I don't get on here tonight, this is never going to happen. So I will put it up as a video and maybe people can watch it on replay. It's quite an important video. It told me a lot. I did a lot of research into the plea deal. And I came back to this video. It's actually the launch of a document that the NACDL... Can you hear me okay, Justice? I hope you can, because I've bought a new microphone and it wouldn't show up on my, what do you say? Things to click on. I was like, where is this new microphone showing up? And it wouldn't show up. So I'm glad you can hear me. My computer microphone was just getting worse and worse. So I'm hoping it's okay. So thank you for joining me, Justice. It might just be you and me, but hey ho, it is what it is. I hope you're having a good Easter. I jumped on tonight because I planned to come on last week and my son was supposed to go and stay with his dad and that fell through. So I couldn't really expect him to go and hide elsewhere in the house while I did my live stream. So I've jumped on tonight because he's with his dad and I've got peace and quiet. So I thought, right, okay, let's just get on there and see how it goes. So, okay, I'm going to now try and share this screen. I hope it won't be too lonely and boring for you, Justice. So we'll go ahead. I just want to show this video because it says a lot about what is going on. And this is statewide. This is US-wide, not just in Idaho. It seems like the plea deal is what's happening everywhere. And that would make sense as to why Ray, so we've heard, I think I heard this via Lana on Truth and Transparency, that he has been doing some work on how to, I can't remember the exact words, but how to avoid the plea deal, the plea bargain. And this video that I'm going to show you, obviously I'll have to pause it as I'm going through for copyright reasons, but it explains very well what is happening in the justice system. And I'm not deliberately picking on the states. We've got our own problems here in the UK, trust me. But as this is relevant to the Idaho 4 case, I thought I would show you. So bear with me 1 second. I'm going to share screen. Everything is very rusty with me here, so bear with me. I'm going to share the screen. And where is it? Launch of the trial penalty. So I'm going to share that. And let me go back here. And that's great. I'm on the side there. Oh, hi, Kate. Okay, thank you, Katie. I did not know your name was Katie, or if you had told me before, then I apologize. I forgot. So, okay, I'm going to start playing this. And let me just make sure I've got the right thing here. And let's go.
My name is Rick Jones. I'm the president of NACDL for just a few more weeks. And this is maybe one.
Sorry. Oh, is it not sharing? No, hang on. Right, sorry guys, bear with me. I'm going to have to find that again. I'm sorry about this. I will edit this video before I put it up. So hang on a second.
Last times that I have the opportunity to A, say that, and B, to be in front of a gathering like this. So this is a special opportunity for me. I am pleased. Norm asked me to really kick this off and then get out of the way, and that's exactly what I'm going to do. But there are just a couple of things that I think bear mentioning. One is the launch of the trial penalty report is really just another step in a series of really important and groundbreaking work that NACDL has done over the last 5-10 years or so in terms of really looking at systemic issues in the criminal justice system and taking them on head on, and not just doing a deep dive into the issue and writing a report, but then making sure that the report has teeth and that there is actual change and reform that comes out of these reports. And so I'm really pleased to be at the launch of the trial penalty report, and I expect that a lot of the substantive things that you see in the report, the principles and the recommendations, will actually over time come to fruition, and we will see gradual and maybe even not so gradual change in our justice system. That is sort of the continual struggle and requires continual vigilance. The really good thing about the trial penalty report is that it really does bring together the entire bar. This is not an issue that is just a public defender issue or a big law firm issue or a solo practitioner issue, the trial penalty and clients who suffer from the vanishing trial in our justice system span the entire spectrum of litigation that happens in this country, and everybody at some point or another who finds themselves in the role of defendant has to confront the trial penalty. So I am pleased to be able to bring you all together and to really get this thing going so that we can work to change what has become, sadly, the vanishing trial.
This is actually going to be a bunch of speakers from different organizations and law firms, and they are sharing their experiences with the vanishing trial, the death of the trial by jury, and also the trial penalty. Now, the trial penalty is the price you pay for exercising your constitutional rights. So it's the bargaining tool. It's, well, you know, if you plead guilty right now, as in the plea bargain, you may do 2 or 3 years in prison. If you go to trial, if you lose, you could do 25 to life. So that's the penalty of going to trial. And this is becoming a huge problem. And in Koberger's case, we know that the trial penalty was losing his life, was death. So bear that in mind as we continue.
In America. The other point that I really want to make is, you know, and it really is sort of deep-seated. I mean, I teach trial practice, of all things, at Columbia Law School in New York, and I've been doing that now for more than a decade. And my students are, you know, they go on to become federal and state public defenders, federal and state prosecutors, federal and state judges, folks who work as litigators in large firms and small firms. And the thing that I've lamented for a decade now at Columbia Law School is that the place where these folks go who are going to be leaders and shapers of our profession, the law school at Columbia has no moot courtroom. And I think that is a indication of what we mean by the fact that they've made a conscious decision that the law school, because of the vanishing trial and other things, doesn't need a moot courtroom. We can teach the fundamentals and the foundations of trial skill and trial practice and trial advocacy by moving some chairs around and trying to figure out in a courtroom how to make it into a court.
So that's quite striking, isn't it? I think. Hello, Hollyberry. Really good to see you. Thank you for joining. It's going to be a quiet one, and I will edit it for replay later, because I think this NACDL video, as we move on, says so many important things and gives some great examples of what's going on. So that's really interesting to me that I think he said University of Columbia, they don't even have a mute courtroom. They don't bother with that now. And you'll find out later in the video how few cases actually end up these days at trial. It's becoming extinct.
And so the last thing I want to say, and then I really will get off the stage because I've probably been here too long, is that just like everything else, and I would be remiss if I didn't say this, just like everything else in our criminal justice system, it's true that the trial penalty impacts everyone in our profession, everyone in the justice system, everyone who finds himself in the role of defendant, but it inordinately impacts the poor and people of color. And so we have to be mindful of that at every step along the way as well. Those are really my thoughts. I appreciate you taking the time to give me this opportunity to kick this thing off. And now I'm going to turn it over to the real wizard of NACDL, Norm Reamer, the executive director.
Okay, so before we get on to this guy, his name will come up in a second. when I went through this video a couple of times, and I was originally going to create a video and make notes, but it became a huge task. So I thought, you know what, I'm just going to play the video and go through. And I'm sorry, I'm going to have to keep stopping it, but you know the drill. It's copyright. But he made a very good point there. It's mostly people of colour and poor people, i.e., those who cannot afford their own lawyers, who face the trial penalty, and it is important to keep that in mind as we carry on watching.
I'm not exactly sure that I told my president to get out of the way, but thank you, Rick. Thanks for the introduction. And also, I want to acknowledge not only, as Rick mentioned, he's got a couple more weeks to go as our president, but our next president, a fabulous attorney from Atlanta, Drew Findling, is here. Drew, why don't you stand up for a second, so everybody.
Can I just apologize as well for playing the whole thing? I could probably skip through some of this, but I don't know if I'm going to skip through some important stuff. So bear with me. They're obviously having a nice dinner. It's the launch of a report. So there's clinking of cutlery and all that sort of thing going on. But as I said, there's some really important stuff here. So try and ignore that bit.
Everybody can see you.
Hi, my name is Tammy, and I would like to give you a few reasons why you should consider.
Our soon-to-be president-elect, Nina Ginsburg from Virginia, is also here. Our immediate past president, who really is going to be speaking in just a couple of minutes, who played a tremendous role in our taking on this project, Barry Pollock, is also here. Barry. And I guess, you know, he's sort of synonymous with the Innocence Project because he founded it and he has led it for all these years. But NACDL's past president, Barry Scheck, is also here. And just, I want to acknowledge the tremendous work of my colleagues on the staff who made this possible, and the task force that worked on it. Today, we're beginning an effort to resuscitate a fundamental constitutional right that is, quite frankly, nearing extinction. It's the right to a trial by a jury of one's peers in a criminal prosecution. The trial penalty is the vast, often geometrically increased difference between a plea offer and what someone faces after trial. It's transformed the criminal justice system into one in which any rational person, even an actually innocent person, must seriously consider a plea offer.
And there we have it. Even an innocent person must consider a plea offer. Obviously, we're playing this with Bryan Kohberger's situation in mind. I am not sitting here saying Bryan Kohberger is innocent. However, I'm leaning towards that way. I have yet to see evidence for me that incriminates him whatsoever. So keep all of this in mind as we continue watching. I'm sorry I have to keep pausing and making comments.
And the conditions that attach to most plea offers not only require the waiver of the trial itself, but frequently come at the price of having to waive other fundamental constitutional rights, such as the right to challenge unlawfully obtained evidence, the right to discovery, the right to an appeal. The manipulation of the potential penalty, usually by prosecutors who have been given virtually unreviewable discretion over charging, but in some states, even by judges who place a high premium on speedy disposition.
I'm muted. Sorry, guys. I wanted to say there, he makes a really important point about the judges, and many judges give a speedy process high priority. And as we're keeping the Hitler Kohberger trial that didn't happen in mind, I can only think of Hitler here. And this is all my opinion. I have to stress that. And I'm not sitting here saying that Brian is guilty or innocent. However, I've yet to see evidence to prove that he did these crimes other than the fact he took the plea deal. So, yeah, I thought that was a really interesting point he made there. You know, the judges like to see things wrapped up quickly. So I'm keeping that in mind.
Creates a pressure to waive the right to a trial that's virtually irresistible. The effects of the penalty and the concomitant abuse of plea bargaining have infected virtually every aspect of the criminal justice system. And as Rick said, it affects everybody. Yes, disproportionately minorities and poor people, but everybody who ever comes in contact with the criminal justice system has to come to grips with this. It's certainly prevalent in the federal system, but it is no less prevalent in state courts. And in terms of sheer numbers, it's very likely that the most devastating impacts of the trial penalty are in the nation's misdemeanor courts, where the assertion of the right to a trial can leave people languishing for weeks or months or sometimes years, sometimes with no counsel and often in custody. In a nation that arrests 10 to 12 million people a year, that is a horrific concept. With jobs and family and homes on the line, it's no wonder that more than 97% of all people plead guilty.
So there's that figure. 97% of all people plead guilty, and many of them don't have counsel. Many of them are sitting in jail for months and years, awaiting trial, and more often than not, the trial doesn't happen. And he brought up a very important point slightly earlier, that, you know, it's the trial is there to examine the evidence. As we know, as we're all disappointed this didn't happen in the Idaho 4 case, but also evidence that's obtained illegally doesn't get questioned. It gets swept under the rug. And I think we all know that this is what has happened in Idaho. I really do.
So today is the culmination of a long process, the research, the studying, the gathering of stories for the report, but it's the beginning of an even longer and more arduous journey. With the release of the report today, NACDL hopes to begin a reform movement that will save this basic right. While the report focuses primarily on the federal system, our advocacy, and I hope the advocacy of many of the groups that are represented here, will focus as much on the states. The founders of the country recognized that the right to a trial, the interposition of one's peers as a check on the government abuse of power to prosecute, was essential to the preservation of liberty. The ability to test evidence, both its legality and its factual sufficiency, is essential to prevent tyranny. No one should be forced to surrender those rights through institutional coercion. Now, for those of you who, many of you in this room are defense lawyers, but for those of you who are not, if you've ever seen a court conduct an allocution in conjunction with the entry of a guilty plea, you know that the most critical question asked of the accused is whether or not anyone has threatened or in any manner coerced them into pleading guilty. Anyone answering other than no to that question buys a one-way ticket to the trial penalty.
For me, that's massive. He says so much there. We look at Kohberger's case and everybody asking why on earth would he have taken the plea deal? All the guilters, he's admitted it. He's admitted he did it. We know that they tried to get the death penalty off the table several times, many times. The only way he was going to save his own life was by taking a plea deal as a guarantee. The gamble at trial was massive. He had everyone against him. I kind of see it like, imagine standing in a field and you've got an army coming towards you and it's just you and they're all against you. The only way you can survive is to surrender. And I personally feel that is what Brian Kohberger has done here. He said it there. How can you stand up there and say you were coerced? You can't. If you want to save your life or have a lesser sentence by taking a plea deal, you have got to agree to their terms. And we all know how interesting the so-called terms were in the Idaho 4 Brian Kohberger plea deal. All they wanted from Kohberger was that he would say he did it, that he wasn't coerced, that he would waive his right to appeal, and there was no problem with his counsel. He had to agree. He had to agree to those 4 things to save his life. He can't stand up there, can he, and say, you know what, well, actually, I'm not happy with my defense counsel and I feel I've got no other choice than to take this, because then he wouldn't be able to save his life. It's not rocket science. And I think this guy says it very eloquently. You know, if you stand up and say that, you're going straight to the trial penalty, which is the maximum you will pay if you're found guilty in a trial by jury. What we all know, all of us who are open-minded in this case, is that there were no other conditions. The prosecution, nobody wanted to know anything else. It was their opportunity to get answers, but they chose not to. And that in itself speaks volumes to me. I smell a lot of stinking rats. I really do. Anyway, let's continue.
But what is it, if not coercive, to present a person with the choice of getting a limited certain sentence versus the risk of a geometrically increased penalty if convicted after trial? Not just a few weeks or months, but sometimes years or decades. And if the prosecutor, a public servant charged with doing justice, has determined that a particular sentence in a plea offer is sufficient for punishment, for deterrence, and for protection of public safety, where is the justice in seeking a multiple of that sentence simply because the person asserted their rights? But that institutional coercion has now become a staple of our nation's criminal justice system, and it's time to end it. NACDL doesn't hold any particular party accountable for how the system has evolved, nor do we assert that all plea bargaining must be eliminated. But the vast differential that bears no relationship to justice or fairness and that extracts the waiver of all manner of rights to promote a speedy disposal of the case simply annihilates a fundamental right. I cannot tell you how grateful I am for the array of groups that are represented here today, many of whom will be speaking, but this support is so heartening to me. As we have seen increasingly in recent years, criminal justice reform is probably the one area in the national discourse that truly has begun to transcend the ideological spectrum. But the presence of so many of you here today is proof that there is a real desire to tackle this problem. And we're prepared to do it with you, with our affiliates, and we look forward to that. And I personally, having practiced for 20 some odd years, have been waiting my entire career to take on this problem. And I'm really thrilled to be at the beginning of this process today. So as far as our program goes, yes, we have a lot of speakers, but I think it's going to move pretty quickly. Basically, we're going to do this in certain segments. First, we're going to hear some very brief remarks from those who had a hand in producing the report and from one organization that actually inspired it. Then we will hear from the author of the foreword, John Gleason, former district court judge, who has spoken out with eloquence about the tyranny of the penalty, both on and off the bench. And then we will hear from a number of reform groups from what we generally refer to as the right, the center, the left, as well as a distinguished frontline practitioner. And in these presentations, we're going to be presenting some of the real horror stories that show the trial penalty. You'll hear of innocent people who pled guilty out of fear of the penalty. You'll hear of innocent people who received geometrically increased penalties over what was offered before trial, even though their eventual exoneration proved that they were absolutely right to go to trial. And then we will have an opportunity for questions and answers. So I'm, as I said, thrilled to be launching this. And it's now my pleasure to introduce the NACDL leader who's been working on this project for several years now and helped to make it a reality, Barry Pollock.
Yeah, I've read the documents. I don't know what to call you, Holly Berry. It's such a nice name, fellow UK. Yeah, I've seen the interviews. I think that maybe one or two have slipped me by, but I've tried my best to keep up with everything. And as I said, at this stage, I'm suspicious of everyone apart from Brian Koberger, from the judge to law enforcement to the roommates to Molly. I've just, every time I thought it couldn't get more shocking, I got shocked some more. I'll do a lot more lives. I'm happy to be back, and I'm happy to be continuing with the case, because I did shut the door on it, and then I took a step back because I needed a break from being on the channel. I had a lot of stuff going on at home, and I thought, I don't know where my head's at. When you took the plea deal, I just did not know where my head was at. And then as the information started coming out, I was more and more shocked. And every single thing that all of us thought and questioned, all of us who had an open mind, I still haven't had answers. In fact, I've got more questions. And what I love about this video is it explains what is going on in the justice system. And it also is really heartening to see lawyers and professionals who care about this, who genuinely give a damn about people's lives. And that is what justice is. It's caring about people's lives, whether they're the victims or the accused. So yeah, let's see who comes up next. It's not actually that long a video. They have got lots of speakers, but a lot of them are quite fast. But again, the information is excellent. Yeah, I'm still getting shocked. Every day something comes up on this case and my jaw's on the floor. I just don't understand how there's so much wrong with it and so many people just accept it. I really struggle with that. I really do. So let's see who's up next.
Thanks, Norm. It is a very curious problem that brings us all here today. Our country was founded on one of the basic principles that no person accused of a crime should go to jail unless and until the evidence against them has been tested through the adversary process and a jury of their peers has found them guilty. We have created, and are rightfully very proud of having created, the gold standard of criminal justice for the entire world. Having created that gold standard, we've now layered onto it every reason we can possibly think of to make sure that it's never used. That is a curious result and unfortunately a devastating result. I know from my own practice that there's a basic math problem that I share with clients all the time. I sit down with the client and I say, I've looked at the evidence here, at least the evidence that the government's been willing to produce to us so far, and it seems to me you have a great defense. What you did here, your conduct here is very defensible. I think if we go to trial, we have a 75% chance of winning. Now, if you plead guilty, you'll get no more than a year in jail. If you exercise your constitutional right to go to trial and we lose, you'll get 10 years in jail. So do you want to take a 25% risk that you're going to spend 10 years in jail? And I can tell you what the answer to that question is about 97% of the time.
There we have it in layman's terms. If you want to plead guilty right now, and bear in mind this person may have already done 9 or 10 months in jail, if you plead guilty right now, you'll only have to do a year. We've got a great defense. I'll put it at 75%, your chance of winning. Do you want to gamble? It's a gamble. They're gambling with their lives. If you lose at trial, you'll get 10 years. And the penalties are a lot larger than that as well. And that is why 97% of people plead guilty.
I'll go ahead and plead guilty. And so the evidence is never tested. The jury never hears what is probably a meritorious defense, and somebody goes to prison without the right to a jury trial ever having been exercised. And I know from my time as president of the National Association of Criminal Defense Lawyers that this is not just an issue I face, and it is not just an issue in blue-collar cases or in white-collar cases. It is not just an issue in drug cases and in other types of cases. It is one of those rare issues that cuts across all criminal justice cases. I heard from our thousands of members who have a front row to the criminal justice system every day about this issue more than any other. Cases that should be going to trial are not being tried, and juries are not hearing them, and people are going to jail without that evidence ever being tested.
There we have it. People are going to prison without the evidence being tested. Now, in my opinion only, this is why there was a plea deal. I think our dear friend Eddie was always right. He said to us that this was never, ever going to get to trial. I wasn't sure at the time. With hindsight, I'm starting to feel like everything was an act up until the plea deal. I think it was a pretense, and that, again, just my opinion. But Hitler, the way he just dropped in court, you know, you might want to consider, you know, it's the last chance to offer a plea, and just dropped it in so casually, and next thing he took a plea deal. I truly believe it was always on the cards, because I don't think for 1 second this case was that the evidence was going to be properly looked at, because there wasn't any evidence. I don't think that Bill and Ashley and the rest of them would ever put Dylan and Bethany on the stand. They couldn't risk that. That's why they rushed a grand jury indictment through. They talk about grand juries as well in this video, and it's fascinating what they say. It's happening every single day in every town and city near you. It really is.
This is a problem, as Norman said, that has gotten the attention of political people who are typically thought of as being on the right wing of the spectrum, and people who are typically thought of being in the left wing of the spectrum. Our report offers a number of recommendations as to how to attack this problem. I suspect that not everybody in this room or everybody in the public will necessarily agree on every one of those recommendations. But I hope today will at least begin a consensus that this is a serious problem, a problem that is affecting justice in our country every day, and a problem that we need to work in a bipartisan way to address. Thank you.
Thank you, Barry. You know, over the last few years, I've had an opportunity to work on a number of projects, including the Clemency Project, and have seen the tremendous generosity of many of the firms in our country. But few of them can compare to Skadden Arps in terms of their commitment to pro bono. And this report, really the gist of the research and going through all the surveys and the responses and interviewing the various lawyers, was all the product of a phenomenal team at Skadden. So I'd like to introduce their pro bono counsel here in DC, Don Saltzman.
Thank you, Norm. And I just want to congratulate the NACDL for being at the vanguard of this critical reform movement. I'm the pro bono counsel, as Norm said, at Skadden. And Skadden is grateful for the opportunity to have worked on this report with the NACDL. The trial penalty that this report discusses is real. It tilts the criminal justice system dramatically away from the Sixth Amendment's enshrinement of the right, the fundamental right to trial, and it can empower a prosecutor to all but eviscerate that constitutional right. And the trial penalty leads to enormous injustice.
I thought that was really interesting what he said there. Hi, Lee. Lovely to see you, and Susie, and thank you all for joining me on this Easter Sunday. And just quickly, as you know, I have to keep stopping for copyright reasons, but I do want to comment as well. You know, he's saying there that it gives the prosecutions the ultimate power, you know, to offer a plea deal. And it tilts the justice system in a certain direction, away from justice, frankly. As we go on, you'll be quite shocked at some of the cases they talk about. As you saw, the last speaker was quite short. They're quite short, but they have some great things to say and comment on.
As the anecdotes and data in this report show. Now, I'm speaking today briefly, mostly because of maternity leave and geography, and I'll explain what that means. Elisa Klein, a Skadden associate in our Wilmington office, and Esther Blaustein in our New York office were the real leaders of this effort at our law firm. Elisa is home with her son on maternity leave in Delaware, and Esther had a client commitment today that she couldn't break. And for that reason, I'm here to talk a little bit about what our team did at Skadden. And it was a big team of lawyers and legal assistants and other staff to help with this report. The Skadden team began its work on this by consulting not only with Norm and with Barry and people at the NACDL, but also with Jamie Fellner from Human Rights Watch, who's the principal author of the parallel report on the trial penalty in the federal drug crime arena. The Skadden team then gathered examples of the trial penalty, egregious examples and some not as serious, but all nevertheless unjust. And then the Skadden team interviewed lawyers who represented clients, prosecutors, judges, people referred to us from a survey that NACDL did, people who were referred by the Federal Defender's Office, and many, many others. And our lawyers then gathered the case files in order to document the injustices that had happened in those cases. And then finally, the Skadden team sifted through data from the Sentencing Commission with the valuable help from Jamie Fellner and her colleague Paul Hofer, who is their resident guru on all things Federal Sentencing Commission related. And then finally, Elisa Klein wrote the bulk of the first draft of the report. And then with the help of an NACDL task force, which was comprised of outstanding attorneys from across the country, as well as staff members at the NACDL, that group honed the report and collaborated with the Skadden team to develop the report's principles and its recommendations. And I just want to add that I'm really encouraged by the impressive array of support for this report by a broad spectrum of groups, many of which are here today. Your commitment to reforming the federal criminal justice system with the goal of reinstating the right to trial is vital to this effort. Thank you.
So as Don alluded to, every great project needs an inspiration. And for us, the real inspiration to take this part of the project on came from the Human Rights Watch, called a report called An Offer You Cannot Refuse, which studied the trial penalty exclusively in federal drug cases, where of course you have most of the mandatory minimums and so many different kinds of enhancements. So we then, inspired by that great work, decided to look at the whole federal system as a way to create a platform for this reform. And I am extremely pleased, since my time here at NACDL or shortly thereafter, I've been privileged to work with Nicole Austin-Hillary. She had been with Brennan for quite some time, but she's now here as the Executive Director of U.S. Programs for Human Rights Watch. Nicole, be honored to have you speak.
Thank you so much, Norm. I'm glad you didn't put a year on when we first started working together. Good afternoon, everyone. I have to tell you, I have the very enviable position of being able to come and talk about work that I had nothing to do with. As you heard earlier, my former colleague, Jamie Fellner, was the principal author of Human Rights Watch's report, An Offer You Can't Refuse, which we published in 2013. And I talked to Jamie for a few minutes this morning, and I let
I just wanted to pick up on what she said there. An offer you can't refuse. That is the plea deal. That's what's going on. And they talk about a range of cases as we move forward. Some are much smaller, some are much larger. But as I said before, we've got to keep in mind how we would feel if we were Brian and your life is on the line. Talking of jury trials, I also feel that he would have seen, and his defense team would have seen quite clearly, with the help of mainstream media and even the judge, the bias towards him already. He was never going to get a fair trial, and he would have been very aware of that. They were very aware of that. So even though they talk about the trial penalty here and how it's everyone's right to have, a trial by jury, imagine knowing that your jury is probably going to find you guilty. And I wanted to make this video because it's the one question, isn't it, really, that we've all got. Why would he have taken the deal if he didn't do it? When it first came out, I thought, there's no way I would admit to doing something I didn't do. He must have done it. How could he do that? And so I've actually spent hours looking into this because I want to educate myself on what is going on. And I'm so relieved to see so many people in the true crime community wanting to educate themselves about the reality of the justice system and what goes on. We've got to have empathy for everyone in this case. And the empathy I've got for Brian is if I were in his shoes and I saw the absolute bullshit that was coming out from mainstream media, and none of them have redacted the lies that they spread. It's shocking what has been allowed. We see Bill Thompson having a hissy fit in court that, when the surveys were coming out, and he's like, well, you know what? He wasn't stalking. He wasn't stalking. And now you've planted that seed in people's minds. Now, they may never have thought he was stalking. He's talking out of his backside because mainstream media were plugging that every day. And he didn't have a problem with that. But he did when it came to the survey. And rightly so, it's, I don't understand why these people who are spreading these lies, including the G family, aren't held accountable for that. So how was this guy ever going to get a fair trial? In my opinion, his situation was a lot worse. I mean, some of the people they talk about in these cases were guilty of something or other, something like smaller offences. And they just got a much better deal taking a plea than if they'd gone to trial. But if your life is on the line, haven't we all got a gut instinct, a fighting soul to save our lives? And it's completely changed the way I had thought at the beginning when he took the plea deal. It's like, well, hang on. If that was you and you saw what was going on out there in the public, you even had the G family interviewing potential jurors. He didn't stand a chance. In my opinion, he only had one way to save his life, and the prosecution knew it.
Let her know that I'd be taking a little bit of glory for her, but that I'd send her pictures. I will tell you, I am so privileged to hear that this work continues, as was Jamie. We know that the work we have to do is not just about the trial penalty. It is about the trial penalty, but it's so much bigger. For those of us who are in this room who believe that we have to reform and improve the way our criminal justice system works in the United States, we know that this is a core part of it. And a very core part of it is about the data and the research that goes into these reports. And it's really about the human face that tells these stories. Because we can give all the numbers we want, and we know that numbers make a difference. It's what undergirds the research. But hearing the experiences of the individuals who have had their rights questioned, who have had their rights taken away from them and had them challenged, that is what is at the heart of the trial penalty issue. And that is what inspired Human Rights Watch to do the report that Jamie worked on in 2013. And I know it's part of what inspired the work of NACDL to continue this work and look at it on a larger scale throughout the entire federal system. So I am so pleased that this work continues. And I am also pleased that we are going to continue with this fight. One of the things that Jamie and I talked about this morning was that the work has to continue beyond this. We know reports are important, and they are very pretty. But we can't just let them sit on shelves and collect dust in our offices. We have to go to Capitol Hill, even though some of those people don't want to hear from us and they don't want to talk to us right now. But we know we have a job to do. We have work to do. We have to talk to the folks in the Capitol. We have to talk to the folks in state legislative houses throughout the country. We have to tell these stories. We have to give them these numbers. We have to tell them that mandatory minimums don't work. We have to tell them that people deserve the right to a fair and free trial among a jury of their peers. And we have to let them know that these faces and the names and those families that are impacted by these issues, that is what matters. And that for any of us who believe in democracy and value democracy as we know it, this is a problem that has to be dealt with. So I'm pleased, Norm, that Human Rights Watch helped to serve as a catalyst for this work. And I am doubly pleased that in my new role as executive director of the U.S. program, that I will help to carry the torch further, because I know that with the release of this report today, it's not the end, but it's the beginning of work that I think we will all continue. And I am proud to be standing arm in arm with you to do just that. So thank you so much.
Okay, I've been told that we're going to take a short pause in the program while the servers serve the entree, and then we will hear from our keynote speaker. I think I had an occasion to have a case with John Gleason when he was a prosecutor, but I don't think it was a case, it certainly wasn't a case that went to trial. But the first time I really ever heard him speak, I had been invited to the Second Circuit Conference, and I heard this judge, this man, give a speech, and it was something like I had never heard before. Now, I realize, Judge Gleason, that the worst thing that can happen for anybody is to get a buildup like that. But the truth of the matter is, you do have a reputation as being a phenomenal speaker, a thinker, and a caring person. John Gleason, who served for many years on the Eastern District, is now a partner at Debevoise and Plimpton, and graciously, having written an important, very, very important decision that really took the trial penalty on, graciously consented to write our foreword for this report. And he's truly one of the greats in our legal profession. So, Judge Gleason.
Thank you, Norman. Thank you to the NACDL and the task force that produced this report, and Skadden, whose participation in this I had underappreciated until today, and the staff of the NACDL.
Do you know, was it 2 weeks ago, somebody put a comment under my...
I really am honored to have been asked to write the foreword to this extremely important report, and honored to be designated on this list of luminaries as the keynote speaker. I'm used to, having been a federal judge, I'm used to undeserved deference and the like, but I haven't been feeling it for the couple of years since I left the bench. So thank you very much for your warm welcome. You know, we all have our formative experiences in life. You know, I grew up in a Irish immigrants household where I was youngest to 7, very devout parents and a bunch of older sisters who were extremely devout Catholics. My brothers and me a little less so, but we were, all steeped in the importance of epiphanies in life. And, one epiphany for me, I'll have to say, mine are all secular, is inheriting this Lucy Cooper case, the case to which Norman alluded. A colleague of mine fell ill and needed some help with her cases. I took this case off her hands, and they showed up in my courtroom, and I had a 35-year-old defendant charged with a cocaine trafficking offense. It wasn't a particularly significant cocaine trafficking offense, but because it involved in a critical way more than 5 kilos, it triggered the mandatory minimum 10-year sentence that prosecutors are permitted to invoke by the Anti-Drug Abuse Act of 1986. So Lucy Cooper was charged with a 10-year mandatory minimum. He's a Staten Island person, 35 years old, had 2 prior convictions for selling marijuana. The government did not think it had a big fish on its hands, so it told me in the first appearance when the case got transferred to me that as long as he pled guilty, it would jettison the mandatory minimum and agree to a guideline range, the bottom end of which would have required Lucy Cooper to spend less than 8 years in prison, knowing full well I might impose, having already expressed my antipathy to the drug offense guidelines, I might have imposed an even lesser sentence. But the kicker for Lucy Cooper was that if he didn't plead guilty by the next day, the mandatory minimum charge would remain intact, and the government would file a prior felony information, the result of which would be, if he went to trial and got convicted, he would spend life without parole. And
So did you get that? This is interesting in more than one way to me. This guy had had 2 marijuana charges and was now on a small cocaine trafficking charge. Let's consider Xana's mother and Maddie's family and the charges they've had with drug trafficking, and they're not in prison. So we all know without a shadow of a doubt that they have struck a deal. And I equally find the rug angle and the frat angle as important as each other. I swing from one to the other. I'm open-minded about both. But Cara Knodel, in her interview with police in the documents, it says quite clearly that she says to the police, this better not have happened because I redacted. Snitched is the word missing there. And we know it is. And we've got Emma Bailey and Demetrius Robinson. None of them are in prison. This guy, Lucy, I think he said Robinson, I can't remember the surname. He'd had 2 marijuana charges and a small cocaine trafficking offense. If he took the plea deal and pled guilty, he was looking at 8 years. If he went to trial and was found guilty, he was going to get life without parole. That's crazy to me. Absolutely crazy. Now that is a great example of the trial penalty. If you dare to exercise your constitutional rights and go to trial and you're found guilty, you're going to prison for life. He didn't kill anyone. He didn't murder anyone. It was a small cocaine charge and he'd had 2 marijuana offenses. Why is Cara Knodel then not in prison? Why did Emma and Demetrius get away with it? And why did Maddie's stepmother get away with it? It's completely obvious to me that they snitched and 2 of their children were murdered. I think huge red flag, massive red flag to me.
The formative part for me was thinking at the time that as remarkable as it was that prosecutors are given that power in our system, that really didn't surprise me. I'd been teaching sentencing for a couple of decades, and I knew those laws were there. The remarkable thing to me was how, and I'm not a believer in the Department of Justice being some evil empire. The remarkable thing to me was that a young, acting in good faith, well-scrubbed, well-meaning prosecutor would actually stand up in court and say out loud that if that defendant did not plead guilty by the next day, he would get subjected to a sentence that no one, not even the prosecutor himself, could justify. He would pay for the right to go to trial, guaranteed to him by the Sixth Amendment, with literally the rest of his life in prison.
I love what he says there. A well-scrubbed prosecutor, how could he stand up and say, if you don't plead guilty by the next day, you are risking going to prison for life, for the rest of your life. If you plead guilty, you'll get 8 years. I mean, I made a comment on someone's channel about the fact that the plea deal is coercive in itself. And someone said to me, you need to read the documents. He was not coerced into taking this deal. Right, I have read the documents. I've been through them all. Whether I can remember everything in every document remains to be seen. But he missed my point, who commented that to me. The point was, the plea deal is coercion. It is 100% coercive. They've got them, well, wrapped around their finger. Well, you know, with Brian, if you plead guilty, then you don't have to die. But you go to trial, and if we're honest, it wasn't looking good for him at trial, was it? Not because of so-called evidence, but because of the propaganda that had been pumped out for actually years. That's why I put in my title, what would you do? What would you do? I would be terrified, because I would know that the damage had already been done. So that plea deal for Brian was coercion in itself.
The other thing that struck me at the moment I heard this scenario that was in front of me was that if I were Lucy Cooper, and I thought if I plead guilty, I'm going to be back out on the street at age 43. But if I go to trial, and if I've got a good lawyer, I know those 2 marijuana convictions are coming in at my trial. If I go to trial, I'm going to die in prison. Even if I were dead, bang, 100% innocent, I would plead guilty on the spot. He pled. Lucy Cooper pled guilty. They don't all plead guilty. I now have a pro bono project at Debevoise, and God bless that firm that it allows me to bang my head and its head against the wall in what I call the Holloway Project. I named it after a case that I handled when I was on the bench that enabled someone who paid a huge trial penalty, thanks to Loretta Lynch's beneficence, enabled him to get the rest of his life back. But I may as well have named it the Trial Penalty Project, because my clients, I have about 15 of them, are typified by Thomas Cathay, Northern District of Texas, when he was 21 years old in 1998 and a heroin addict. He also had a girlfriend, Kristen, who was a heroin addict, and he gave to her some heroin one night. In the parlance of the law, he distributed heroin to her one night. They shot up together. He didn't know that Kristen had also used cocaine earlier that evening. And so she died of an overdose that night. When Thomas woke up, he saw his girlfriend dead and had to be restrained from killing himself. He was prosecuted for distributing the heroin to her. The guideline, the relevant guideline, provides for the possibility, if death results, go directly to a level 43 life guideline range. The prosecutor knew that was ridiculous, so the prosecutor offered Thomas a 15-year deal if he would plead guilty. This was pre-Booker, pre-Burrage, the case that requires there to be more, the but-for causation in terms of causing death. In any event, Thomas, among other things, 21-year-olds with addictions don't always make the most rational decision before them. He went to trial, and he's doing life. He paid for that trial with every day of the rest of his life beyond age 34, which is the age he would have been had he accepted the plea bargain offered him.
So I don't know if you caught that, but that young man and his girlfriend took H together. He gave his girlfriend H at her request. Didn't realize she'd already taken the C drug beforehand. She ended up dying. He was so distraught, he almost killed himself. They had to restrain him. He decided to go to trial, and he paid for that right to go to trial with his life. He is spending the rest of his life in prison because he supplied his girlfriend with the rug that killed her. So let me ask you this. Why is Emma and Demetrius walking free? Because they have done exactly the same thing, but they're walking the streets. This guy paid the price for not taking a plea deal of 15 years. He didn't deliberately kill anyone. She chose to take that H, and it killed her. He's paying for it with his life. I'd like to know why Emma Bailey and Demetrius Robinson are walking the streets.
The last thing I want to do by pointing out what could arguably be called extreme cases, although they're not unusual cases, is to suggest that the evils of the trial penalty are limited to egregious mandatory minimum cases, excessive guideline ranges across the board of case types and categories, account for a system in which the backdrop of plea bargaining is a guideline range that is excessive punishment for the offense. Last thing I want to do is to suggest that the evils of the trial penalty stem only from prosecutorial abuses, from the deployment of mandatory minimums that were not enacted to allow prosecutors to coerce guilty pleas and punish those who refuse to be coerced. It's not only the prosecutorial abuses in terms of threatening onerous guideline range punishments in exchange for guilty pleas to lesser punishments. Judges are also complicit to a degree I failed to appreciate for many years on the bench. Put aside excessive mandatory minimums, put aside excessive guideline ranges. There's a legal culture in which all the participants are led to believe that if you roll the dice, a terrible, terrible metaphor for what is the exercise of a fundamental right enshrined in the Sixth Amendment, that if you roll the dice, then you ought necessarily to feel an extra measure of punishment, another pound of flesh taken out of you. So judges also are part of the problem. Last thing I want to do is suggest to you this is a federal problem. This was alluded.
Well, he says it there, doesn't he? Judges are also part of the problem. I think we know Hitler, the massive part of the problem. If you follow the Delphi case, Gull, huge part of the problem. And they're getting away with it. They are getting away with it every day.
To by Norman in his remarks. The problems of favorable guilty pleas being conditioned on the waiver of fundamental rights affects criminal justice in the states as well. And there are many places in which, unless there is meaningful bail reform, pleading guilty is the only way out of prison. I don't want to suggest for a minute that this is only a problem that afflicts the innocent. Yes, there's an innocence problem. I've alluded to it already. So has Norman, so have our other speakers. But, we live in a system in which we have accepted as a premise of our criminal justice system that you don't go to prison just for being guilty. When I was on the bench, I had a number of defendants come before me, especially those from other countries, other justice systems. And I'd say, why do you want to plead guilty? And they'd say, because I am guilty. And I would explain to them what to many seemed counterintuitive. I said, you don't get punished in this country for being guilty. We've chosen a system of justice in which unless the government can prove you guilty beyond a reasonable doubt, this was the point that was made earlier, you don't get punished. So some will say, prosecutors will say, what's wrong with a system that too much induces actually guilty people to plead guilty? There's plenty wrong with that. We have decided that you only get punished if the government can prove you guilty beyond a reasonable doubt. And to the extent prosecutors are empowered to create a world in which only the extreme risk assumers will exercise that right, then now we're getting close to extinguishing it, not just excessively burdening it. The fact is, we should all be alarmed by the reality that trial penalties have driven the guilty plea rate from slightly under 80% when this new regime, this new system that was imposed upon us that we created in the mid-'80s, we've driven that guilty plea rate up to the 97%, where it has remained constant for several years.
Very interesting. So the plea deal, I think, became big in the 80s, he's saying there, and those pleading guilty was at around the 80% mark. Now it's a constant 97% mark. And he said a little bit earlier, your only way out of prison is by pleading guilty. It's shocking. And for Kohberger, the only way you're going to save your life is if you plead guilty. They knew how desperate he was to take the death penalty off the table. And as I said earlier in the video, Hitler just dropping it in there at the last minute, you might want to consider a last chance to offer your plea deals. And lo and behold, there was a plea deal. I think it was planned the whole time. This was never going to trial, in my opinion.
I've been teaching investigations as well as sentencing now for 30 years. And one of the cases I teach, and there's so many ways to access this problem. The way I choose to access it is informed by the baggage I bring to the podium. And that includes teaching about federal criminal investigations. I teach Calandra, right? The case, Justice Powell writes the Calandra decision for the court in 1974. And that case says, if evidence was seized from you illegally, you may want to keep that evidence out of the grand jury that's looking to indict you, but we're not going to let that happen. We're not going to slow down the charging process with motions to suppress in the grand jury. And the court reasons through Justice Powell's decision. One reason for that is we don't have to worry too much because it's going to come out in the wash at trial. If a prosecutor is sufficiently unwise to obtain an indictment based on evidence that can't be used at trial, the person will be acquitted at trial. In the Williams case in 1992, a case, I was a prosecutor at the time, I was struck by the holding. The holding was there's no obligation for prosecutors to present substantially exculpatory evidence to the grand jury. So if you're the target of a grand jury investigation, you're the one the prosecutor wants to indict, there's no obligation for that prosecutor to present evidence that substantially exculpates you.
Did you hear that? Grand jury indictment. By law, they do not have to present exculpatory evidence to a grand jury. Absolutely shocking. What they want to do is just speed up the whole thing. Nobody's cross-examined, and their point is that they don't show that evidence because they tell them it'll all come out in trial. It'll come out in the wash. You know, he will be set free at trial because that's when the evidence gets examined. But what happens when there's no trial? That evidence never gets examined.
To the very grand jury that she's going to ask to indict you. The rationale, again, Justice Scalia writes for the court, cites Blackstone, and says the one reason for diminished concern is this is a charging process. It's an accusatory process, quote, which is afterwards to be tried and determined. Citing Blackstone. You know, and the last thing I'll say on this.
So you hear that? The grand jury, it's all about the charging process. So Koberger's grand jury, they will have just presented the PCA. You know, maybe some other bits and bobs, but the point is, it's not a trial. So they don't get to cross-examine. They don't get to question anything. It's a space, a secret space, where the prosecution gets to present their side of the story. And by law, they do not have to show any exculpatory evidence because that will be brought up in trial. And then what happens? They have a plea deal and that evidence is never, ever examined, which is exactly what has happened here. And more importantly, they don't even get to question the evidence that was illegally obtained. It all gets brushed under the rug. It's very warped, very corrupt, and there's no way out.
This score, and I'm going to sit down in a minute, Norman, I promise, is, you know, grand juries are frequently criticized for not being the buffer we want, right? Saul Wachtler said it in New York. You know, the grand jury would indict a ham sandwich. Well, it's not their fault, right? They're given a probable cause standard. There's no unanimity requirement. There's no rules of evidence in the grand jury. There's no cross-examination in the grand jury. It's easy to indict. We've decided to erect a system in which we will accept errors in the charging process. Again, safe in the assumption that the cases that make it through will come out in the wash at trial. And when there's no trial, there's no wash. And we wind up with a system that the metaphor I've used in the forward is it's a trial is part of an ecosystem. And once one part of an ecosystem goes away, the whole thing has to be considered, and in our case, has to be reconfigured. I don't suggest for a moment we should reconfigure the charging process. The right to trial needs to be respected. It's enshrined in the Sixth Amendment. There are any number of avenues for reform. There's legislative reform. If prosecutors can't deploy those mandatory minimums for the purposes for which they were enacted, they should be, don't get me wrong, they should be eliminated entirely. But accepting for a moment that they play a legitimate role in providing for enhanced punishment for the worst of the worst, that's not the role to which prosecutors have put them. The commission needs to formulate sentencing ranges that don't unduly coerce people to accept the offers made by prosecutors. Prosecutors obviously need to exercise their discretion in a way that doesn't unduly burden the exercise of the Sixth Amendment right.
Sorry, I was muted. So let's think about Koberger's situation. They were ready to go to a preliminary hearing. We all heard that Bethany Funk had exculpatory evidence. Well, according to what this guy here says, there was no reason for that exculpatory evidence to come out in a grand jury. Whether that's different in a preliminary hearing, I've got a feeling it's different. I'll have to look that up. But the minute we heard that Bethany Funk had exculpatory evidence, there was an immediate secret grand jury. And so Brian's situation is that he's held accountable in a charging process at the grand jury, and all they had was the PCA. And we all know now there is nothing in that PCA that incriminates him. I know for a fact, because I've researched it, you cannot arrest someone on touch DNA alone. There has to be other circumstances. They made it up. They made the rest of the circumstances up. So he's at this grand jury. I'm not sure if he went, but this grand jury was happening. No need for exculpatory evidence, and the standard was a probable cause. Even the prosecution said that's not worth the paper it's written on. So if we've got Koberger spending life in prison on touch DNA alone, which that's a whole other video, according to the law, he should not even have been arrested, let alone spending life in prison. Everything else in that PCA was a theory. It was a working theory, and they had no evidence to back it up. And now all of these documents have come out. We still don't have the evidence to back it up. And as someone said earlier, I'm so sorry, I can't remember who said it in the chat. And I forgot now what I was going to say. Yeah, it's the PCA was just a joke. It was just not worth the paper it was written on. There was nothing there that incriminates Brian. You know, everything we questioned when this case was evolving, like, why have they only released stock photos of the Elantra? Why haven't they released the footage? Because they knew that the footage wasn't worth anything. And now we know there were fog lights on the car. But because this didn't go to trial, that will never be questioned. I'm side-eyeing Anne now as well. I think she's part of this process. And I think it boiled down to, do you want to save your life? Well, this is the only way we're going to save your life. And she admitted she wasn't ready. But to save his life, he had to say he was happy with his defense. And of course, a plea deal runs out. It expires. He would have had a limited time period. You're going to have to take this plea deal by tomorrow, or it's going to trial, whether your defense lawyer is ready or not. And these are the conditions, and the conditions are that you're happy with your defense counsel. It's awful and it's shocking, and it's answered all my questions as to why Brian took the plea deal.
The judiciary, as I mentioned, needs to get with the program that just because someone exercises a right that we deem sacred doesn't mean they, putting aside the folks who spend the rest of their life in prison, doesn't mean their penalty should be doubled, even if what they're facing is a 2-year penalty. So I'm going to sit down because I know there's a long list of speakers. Congratulations to the NACDL on this fabulous report, and to all these organizations who are here to support it. It's a fundamentally important issue. The fact that this conversation is elevated by this report and by your presence here is so important, no matter how long it takes for the reforms that are needed to come to pass. Thank you all.
Thank you very much, Judge Gleason. The Innocence Project, if you look at their website, says they exonerate the wrongfully convicted through DNA testing and reform the criminal justice system to prevent future injustice. It's probably fair to say that the Innocence Project and the work that they've done have done more to transform the criminal justice system and raise awareness about injustice than just about any project that's been launched in the last 25 years. But of course, only a sliver of cases have biological evidence. And in virtually all cases in which the conviction turns upon intent, there's virtually no hope of exoneration. It's very rare indeed. So the fact that they can show us that the extent of the problem and prove it beyond really any doubt, is extremely important. I am very personally thrilled and privileged that the executive director of the Innocence Project, who has been a mentor and a friend to me when I came into this position and needed some help and guidance, and throughout all the years, Maddie DeLone, please.
Thank you, Norman, and thank you, NACDL, for including the Innocence Project here today to participate in this important work. The Innocence Project and the other 68 member organizations that make up the Innocence Network have long been concerned about the pervasive and relatively unchecked use of guilty pleas in the American criminal justice system, one in which innocent people plead guilty. We believe that reliance on a plea system is in fact based at its core on a belief that the system holds, even if it doesn't think about it, that only guilty people or people who committed crimes would plead guilty.
So as you know, this lady is from the Innocence Project, and she said, and this is the problem with the guilters, they stand firm in their belief that only guilty people plead guilty. And I hold my hands up. I knew that some, perhaps a very small amount of people did that, but I really struggled with Brian taking the plea deal initially. It was a very quick feeling, but I downed tools for a while. I thought, okay, well, you know what? I wouldn't do that. But I didn't really step in his shoes. I didn't really, even though I knew the big picture, I didn't really think about the big picture. And now when I sit here and I think, like I used the analogy before, if I was standing on my own in a field with no weapons and an army coming towards me, and the only way I could survive was to surrender, the only way I could save my life was to surrender, I'd wave that white flag, because we've all got that feeling. I mean, there are some that say, you know what, I'd rather die than spend my life in prison. I wouldn't, actually. And I think there'll always be that belief, even though I hate to say it. I feel like Brian being exonerated, it's a very slim chance. Because even those, because he's said that he waives his right to appeal, I know there are other avenues, but he's got a big fight on his hands, let's put it like that. But I would still rather be alive than be shot. You know, you've got the G family turning up with, you know, death penalty T-shirts on, and mainstream media never once being open-minded, ever. The judge calling your witnesses conspiracy theorists. He didn't stand, you know, like I said before, this video, it's a lot about the trial penalty and how everyone's got a right to a trial by jury. But what if that jury pool has already been tainted beyond return? This guy didn't stand a chance. He didn't stand a chance either way. In my opinion, the only way this guy could save his life was to take that plea deal. And they knew it. But what she says here is so important. Everyone stands, not everyone, there's a lot of people who stand firm in the belief that only guilty people plead guilty. And that is a wrong assumption.
And do not believe, in fact, that many innocent people plead guilty. For a long time, whether consciously or subconsciously, we've accepted a system of plea bargains. We have felt comfortable as a society, although there are many reasons that have already been discussed today and are well documented in the report, that we should not be comfortable with the current system we have, but we felt it was a system, an efficient way of getting to truth. But as the Innocence Project and our clients across the country and others have demonstrated, innocent people plead guilty to things they did not do all the time. While it's impossible to know just how many people have pled guilty, And because there are a lot of difficulties in sussing that out, often there are not good records in a plea case. After conviction, they're not good records, and people waive their right to appeal, so getting back into court has its own challenges. We'll never know, but we do know that in the National Registry of Exonerations, which is at UC Irvine, there are 409 documented cases of absolutely innocent people, proved innocent post-conviction, who initially pled guilty. Among those are 40 people who pled guilty and whose innocence was later proven by DNA. These 40 people spent an average of 13 years in prison, as many as 27, before DNA freed them. In 84% of these cases of DNA, the DNA exonerees who pled guilty, the person who probably committed the crime was also identified.
See, this worries me, and I think this is where the sheath comes into play. DNA exonerated these innocent people, okay? The prosecution in this case knew that, and there are people out there, I know this, in Harsh's words, this is going to split the room. But with no other evidence against Brian, none whatsoever, they knew that DNA was going to be the clinch. And that is what would have found him guilty. And the Innocence Project only deal with DNA cases. So by the time this swab, not the sheath, the swab got tested, they'd used it all up. The defense couldn't test it. But they also destroyed the house, and any other DNA samples that were available in that property and on the victims was not tested. So where does that leave Brian? In my opinion only, either the sheath or the DNA was a plant. I've always believed that. And that is where they had him by the nuts, frankly. And that is why I think it's going to be very hard for him, because without the trial and, you know, this illegally obtained evidence was never questioned. They don't have to now explain at all how they got to his DNA on the sheath. They don't have to question the chain of custody, nothing. And they know it. This whole case is such a sad, corrupt story.
And in 65% of these 409 documented cases, these were people of color, and almost every one of them, as Rick said earlier, was poor. A few examples, and there are others in the report that NACDL did, but James Ochoa was a teenager arrested for a carjacking and offered a plea that if he took it would result in a 2-year sentence. The judge in the case said that he would sentence Mr. Ochoa to 25 years to life if he lost at trial. Ochoa took the deal, pled guilty, and served a year before DNA demonstrated that somebody else had actually committed the crime.
So I don't know if you caught that, but this guy, it was a carjacking. It was a carjacking. And the judge said, if you go to trial and you're found guilty, you will receive 25 years to life. But if you took a plea deal, I can't remember what she said, was it a year? How can you stand there and tell somebody who's guilty of carjacking that he's going to get 25 years to life? How is that a fair sentence? This is crazy. This is absolutely crazy.
Chris Ochoa was arrested and charged with capital murder. He confessed to the crime after questioning and ultimately pled guilty to avoid the death penalty. 13 years later, DNA would clear him. The NACDL report focuses on the trial penalty.
So there you go. You have someone who pled guilty to avoid being killed. And 13 years later, 13 years of his life in prison, DNA proved he was innocent. My problem in the Koberger case is, how is that ever going to happen for Brian? Yeah, that's frightening.
And while we know what the deals were for these hundreds of people who pled guilty and were sentenced and ultimately freed, we don't know what many of the other 1,800 faced before they chose to go to trial, where they ultimately lost and were convicted for things that they did not do. As you can imagine, it's hard to find the deals offered. A few examples, however, will illustrate the phenomenon. Dwayne Dale was charged with a rape and child sex abuse. He was offered 3 years of probation if he pled to lewd and lascivious conduct. He was innocent. He insisted on proving it. He went to trial. He lost. He was sentenced to 2 life sentences plus 13 years. He served 18 years before he was exonerated. Chris Miller was offered 7.
That's shocking. So what's shocking about that example is that this was a horrible case involving a child, and they were prepared to just give him probation if he pled guilty. So if they really thought he was guilty, they were going to let him out after, well, probation. It was months probation. If he went to trial, he had to, and he was found guilty, 2 life sentences, but he didn't do it. Oh my God, what a mess.
7 years if he would plead guilty to aggravated assault and testify against his alleged accomplice. He went to trial, was sentenced to 40 years, and served 17 of them. While a plea system has a role to play in making a system more efficient, we have come to rely on pleas to our detriment. Pleas that can be made with incomplete information, often with no time to think about the consequences, never a good time for decision-making, with trial penalties that the report describes well, will not get to the truth and will do justice much harm. As our cases demonstrate, innocent people plead guilty to things that they didn't do, and we believe that a system that allows and makes it a rational choice for an innocent person to plead guilty is a system worth fixing. Thank you, Norman, for what you will do.
I love what she said there. A system that allows innocent people to plead guilty is a system worth fixing. It's happening all the time. And like Lisa says, this could happen to any of us or any of our family. It is frightening. It is going on all the time. And what's frightening, this is the way I see it, that these people in power, they're psychopaths. They are, because they don't care about that life. They just want to put the case away and lock these people away. They just want to get it done and dusted. They don't care if an innocent person is put away or sentenced to death. You either take the plea deal or it's rolling the dice. You gamble. And if you choose to gamble, which actually is your right to a fair trial, if you choose that right, you're going to pay the price massively. So many people accused are so frightened of what might happen at trial. I mean, look at Richard Allen. Look what happened to him at trial. How that jury found him guilty, I will never know. It's terrifying. The minute you're arrested, your life is in other people's hands. And we should all be afraid, really, really afraid, because nobody cares about you. Nobody gives a damn. These people do, and this is why I wanted to play this video. There are people out there with uniforms and, you know, professional people who care, and thank God. But it seems to me like they're not making much of a dent in any of it.
So we're going to go to a practitioner now. Fred Hafetz is a practitioner who has written about the trial penalty, has a distinguished practice at Hafetz and Nichelas in New York, has become increasingly concerned about the impact of the penalty on practice itself, and will tell us about a situation where there couldn't be any DNA exoneration, but in which there's absolute proof that by going to trial you can expose the existence of a scenario in which there was no crime to begin with. Fred Hafetz.
Thank you, Norman, and thank you, ACDL, for inviting me to this very important forum on this critical subject. So the case that Norman was talking about, which I want to focus on, it's a client I represented. This goes back to, I'd say, around 2006, roughly. Was facing, about to be indicted in the Southern District in New York. It was a major investigation of New York Stock Exchange specialists, and indictments of many of them were expected very shortly. On the eve of indictment, person I ultimately represented came to see me. He had been represented by another lawyer, and a good lawyer, I might say. And the lawyer had told him, you have a chance to plead guilty if you go to trial, get convicted. There is a huge amount of money in the case. There were multi-millions of dollars. My client was the poster boy for the group of defendants that were going to be indicted. He'd been profiled on the front page of the Wall Street Journal. And the lawyer told him quite accurately, you were facing at least 5 to 6 years in jail. At that point, the client came to see me. We talked. We spent an afternoon talking. As we talked, I realized, at least in my mind, that he hadn't committed a crime. I told the client that. Client said, I agree. I don't think I've done anything wrong. I don't think I committed a crime. A surprise. And our minds met on this subject. And we went to trial. He decided to go to trial. So the government indicted. They indicted this 14 people, all in separate indictments, to be tried seriatim. We were, I think, the third or fourth case to go to trial. A fourth case to come up. Several of the defendants had already pled guilty. We were fortunate. We had a extremely good and excellent district court judge, Denny Chin, in Southern District, New York. And we briefed the case, motion to dismiss beforehand, in an effort to show the judge that there was no fraud in the case. We lost the motion, but I think we succeeded in educating the judge that there really was a significant issue as to whether there was a fraud. We went to trial. The jury convicted him. Immediately after the verdict, the judge then invited, and I say invited, defense counsel to file a motion to set aside the verdict. The judge had listened very carefully to the evidence and had really, I think, been struck by the arguments before trial that there was no crime. We filed the post-trial motions as we were invited to. The judge set aside the conviction. The Second Circuit affirmed the dismissal or the setting aside of the conviction. After that, the government, to its credit, then went and they nollied the remaining indictments. I think there were maybe 8 or 9 that were still left at that point. And to their great credit, they went back and they vacated the convictions of the people who had already pled guilty. So it's kind of a frightening story, but it really is all about the coercive power of the guidelines. I mean, this was somebody who, because of the fear of the financial guidelines, that he was going to be crushed if he had not taken, if he had risk on the trial. So as has already been talked about, and certainly by the prior speaker, about innocent people all the time in this country, because of the coercive power of the guidelines and the mandatory sentences, are pleading guilty.
All the time, people in this country who are innocent are pleading guilty. All the time. Brian's not alone. His case was massive, is massive. It's ongoing as far as a lot of us are concerned. Innocent people are so afraid. That's the key word. They are so afraid because they are surrounded by power everywhere. People who, once you're arrested and they've got something in store for you, you're a puppet and they're pulling the strings. And you have to find the best solution for you. And sadly, innocent people are pleading guilty because to not plead guilty isn't worth it. It's not worth rolling the dice for.
Every day. In essence, the draconian penalties that have been enacted have basically corrupted the criminal justice system. It was Alexander Hamilton, I think, who said that if the founders agreed on anything at all, they agreed on one thing, and that was the importance of trial by jury to check government power. The penalties that are faced by going to trial today have all but made trials all but a disappearing factor in the American criminal justice landscape. Just one corollary to this, and that is that as it's one thing to say that we're no longer having trials and they're diminishing, but the unfortunate corollary of that is that as trials are dying, trial lawyers are dying. That is to say, we are coming upon an era in which there are going to be very few lawyers in this country who are really capable of trying a case, and that's because when the statistics show, as they do from pre-guidelines, 20% of the cases in the federal system went to trial, and now it's below 3%. Similar figures, although not quite as statistically solid as in the federal system, but really, I think, pretty strongly show similar results. So as you lose the trial, you're losing the trial lawyer, you're losing the ability of people who can really make the jury system work. On the other side of the coin, the same fact, we're having an equally substantial effect on the fact that prosecutors don't try cases. Pre-guidelines in federal U.S. attorneys' offices, assistant U.S. attorneys would leave those offices having tried maybe 30, 40, 50 cases. We're in an era now where they'll leave those offices maybe with 3 trials. The problem with lack of trials by prosecutors is they don't know a bad case when they see it. You got to sit there in the courtroom and see your witness get his brains beat out by a good cross-examiner to understand that every case that comes down the pike is not a great case, and maybe you ought to think twice about indicting on what they indict and ask for the kind of offers that they seek. So both sides of that. But then the third part of the triangle is, and Judge Gleason alluded to this, is we're paying a penalty by now having trial judges who are not really trial judges. I mean, you walk through the halls of the federal courthouse in New York, you talk to federal judges there, there are judges who haven't tried a case in 2 or 3 years, or if they have, maybe they've tried 1. The lack of experience, the lack of skill in the trial judges, many of whom come on the bench these days without having tried any cases themselves, it's really quite astonishing. And we pay a big price for that when there is a jury trial. I mean, they are so used to believing and understanding that what the prosecutor puts up has got to be gospel, that you don't have that healthy skepticism you see when a trial judge has the experience of seeing the prosecutor's case being torn apart. And on the other side of the coin, they are not prepared to give the defense lawyer the kind of latitude that a defense lawyer really needs in order to be able to do his job. So all around, it's a loser with regard to the diminution of the skills by the death of trials and the approaching death of the trial lawyer, all brought about, in my opinion, or mainly by the coercive sentencing regime that has been imposed in this country, and notwithstanding Booker, because even with Booker, 10, 12 years later, the statistics in terms of the percentage of people going.
Hey guys, happy membership. I was allowed to gift 10 So I'm really, really sorry if you didn't get one, and I didn't get to choose who got a membership, but I used up my 10 because I want to thank you all for being here. If you did not get a membership, I'll see if I can find a way around that and gift you one, because it really, I am so appreciative that you've joined me on this Easter Sunday, and you've been so loyal. I've been back and forth on this channel like a yo-yo, and I do apologize for that. It's just we'll have a chat afterwards, but I'm gonna have a look now to see who didn't get memberships and see if I can do something about that. But well done to everyone who got one. I didn't get to choose, and thank you for being here, and happy Easter.
The trial is still infinitesimal, and that is because the trial judges themselves, notwithstanding the latitude given by Booker, are still applying the guidelines close to, not as hard a penalty, but as if the guidelines were really ruling the day. So this organization has a lot of work to do in that area. Thank you.
The Texas Public Policy Foundation exists to promote and defend liberty, and Right on Crime brings a conservative approach to criminal justice, fighting crime, supporting victims, and protecting taxpayers. Those are all nice words, but the reality is that Mark Levin has brought more energy to this discussion and engaged the right in thinking about how our criminal justice system is abusing our folks in this country than just about anybody. And I've had a lot of opportunities to be with Mark. He is a font of energy and enthusiasm, and I am really grateful that he's here to support our efforts. Mark?
Well, congratulations to NACDL and everyone who helped with this superb report. And I think from a conservative perspective, those of us who believe in limited government, individual liberty, this is a really important issue. Because, of course, the trial process and juries represent a crucial check on the unlimited, otherwise unlimited, power of government, and in this case exercised in the hands of prosecutors. Now, of course, most prosecutors are very responsible, but the problem is indeed the system and the incentives that have been set up, as we've heard today. A secondary problem is the trial penalty also violates the goals of proportionality and consistency in sentences. Obviously, someone who chooses to exercise the right to trial ends up with a grossly disproportionate sentence to what others and what they otherwise would have received. Now, of course, we've already heard 11% of those claims in the exoneration registry are in fact people that pled guilty. That's a huge problem. I would say it's an even bigger problem at the state level. In Harris County, just a few years ago, 298 people alone were found to have pled guilty to drug charges that later, when the lab test came back, turned out the substance was not even illegal drugs. Thankfully, those have been unwound, but we can't give back to those people the time they spent in jail pre-trial, which is another huge issue. A lot of people, in this case, they pled to time served in jail because they couldn't afford bail. So that leverage also causes people to plead to crimes they didn't commit simply to get out of jail because they cannot afford bail. So there's many aspects of this. Now, there are a lot of solutions, many of which are highlighted in the report, including full discovery, so people can at least make informed decisions at this stage. I'm proud to say in Texas, we passed an open file full discovery legislation called the Michael Morton Act, named after a gentleman who spent 26 years in prison in Texas for a crime he didn't commit. And he was tremendous at the legislature in explaining why lawmakers needed to pass this bill. He was asked at a hearing by the chairman of the committee, "I'm surprised you're not bitter after all these years spent in prison for a crime you didn't commit." He said, "Well, I've had a lot of time to get over it." Rolling back mandatory minimums and for those states where maybe it's not possible to immediately repeal them, certainly adopting a safety valve, which is a piece of model legislation that I and others helped get adopted through the American Legislative Exchange Council. I know Michael Bowman and Ronnie Lampert from ALEC are here. I'm on the Public Safety Task Force, and I hope we can address further this issue of the trial penalty through that task force. Again, making sure that we disclose these plea offers to the judge and the jury before the sentence is given. That would be extraordinarily helpful. I would even argue the parole board should be aware of it. You know, I've read about cases recently where prosecutors write the parole board and say this person can't be released after serving decades, and then it turns out they offered them a sentence that's far below what they've already served in prison. And of course, now we know they've been an exemplary inmate all these years. So it's completely contrary to that fact. One of the things that I've really been struck by is one of the areas we've worked on is restorative justice, things like victim offender mediation. So we had a bill in Texas a number of years ago that we ultimately did pass, but we ran into some opposition from prosecutors. And I said, well, this was district attorneys from some of the major cities in Texas. I said, well, what's your concern about this bill? They said, well, we don't have time to look at the cases to see if they're appropriate appropriate for victim offender mediation or another form of restorative justice because we're pleading them out so quickly. We don't have time to examine them. But they don't want, of course, the victim to be able to pursue that without their approval. So it was a bit of a catch-22. And I know, for example, Common Justice, which is a great restorative justice program in New York City, they actually have to look for innocent people to make sure they're not getting innocent clients into this prosecutorial diversion restorative justice program. So one of the points I really wanted to emphasize, this problem is, if anything, worse at the state level than the federal level. So there was a study in 2007 by a professor at Georgia State University named Russell Covey and some other research, but that particular study found a 292% trial penalty. That was the difference in sentence for a defendant who exercised the right to trial, and that did not consider the fact that they may have been convicted of more serious charges, because oftentimes, of course, the plea bargain involves pleading to lower charges. So that wasn't even included, and including that, you could get from 300 to 500% trial penalty, and indeed, in some cases, 1,000%, which would mean the plea deal was 10% of what the sentence would be at trial. One of the other issues I wanted to raise in Texas, over the last several sessions, one of our priorities has been to work to strengthen record sealing laws. So people, particularly with a first-time nonviolent offense, they could get that off their record. But we've seen some instances of plea deals requiring the defendant to waive their right to seek an order of non-disclosure, or record sealing, as part of the plea. And we need to pass legislation to put a stop to that. Now, we've talked a lot, and I'll conclude with this, the idea that, of course, you suffer a trial penalty by declining the plea deal. But what if it turns out someone else declining the plea deal causes you to incur the trial penalty? And that is the case of a wired plea. And what is that? Well, that's where, and this is an example of a particular case here, but this assistant U.S. attorney said to this client, to the attorney for this client, that he could enter a plea and get 4 years versus potentially getting 30 years at trial, but it was a wired plea, meaning that the co-defendant had to agree to it too. And it turned out, well, the co-defendant with a different lawyer didn't agree to the plea, so they all went to trial and he got 30 years. So this, again, just emphasizes kind of the random and unfair nature of this system we've created. So I think this report will be a huge benefit to us as we move forward, both at the state and federal level. And hopefully, again, we're not talking about abolishing plea bargains, but certainly moving to a system where we ensure fairness and due process much more so than we do today. Thanks very much.
Thank you, Mark.
Hey guys, bear with me. I'm letting this run. I sped it up a bit. We'll have a nice chat afterwards. I'm just going to make sure everyone here has got a membership as a happy Easter present. So bear with me. I had to change my payment method, which is why I've gone away for a minute. So hopefully you're all going to get one in a second.
The Cato Institute is a public policy research organization dedicated to the principles of individual liberty, limited government, free markets, and peace. That sounds like a great mission statement. I'm thrilled that Clark Neely, who is the Vice President for Criminal Justice Policy and who has written on this subject, and next week we'll have a program right here in DC that's going to take another look at this problem from another perspective. Clark, I'm delighted to have you speak to us.
Thanks very much, Norm. I want to start by congratulating NACDL and the team at Skadden for an extraordinary product. I really hope and believe that we're, on the cusp of something with this report. I want to start with a personal story. I've never worked in the criminal justice system. I've been a constitutional litigator for most of the past 20 years. And most of my career I was at a libertarian public interest organization called the Institute for Justice, which some of you may have heard of. And the last few years that I was in IJ, I started working on civil forfeiture cases as part of our property rights work. And I was astonished at the rather cavalier approach that I saw law enforcement taking to the issue of taking away people's property. And over the 4 years that I worked at IJ on these cases, we never lost a single civil forfeiture case. And today, IJ's track record against federal civil forfeiture is unbroken, 100% win rate. I've been a litigator my entire career, more than 20 years. I know that whenever you see a 100% win rate in any area of litigation, something is wrong. And what I began to wonder was whether these people, being law enforcement, if they are this cavalier and sloppy when it comes to exercising the power of civil forfeiture, are they much, much more careful when it comes to taking away people's liberty and putting them in cages? And this began to haunt me. And the more I looked into it, the more I became convinced that the answer is no, that they are not far more careful, and that the same kinds of injustices that I saw working on civil forfeiture cases were not only likely, but to a high degree of certainty, inevitable in criminal justice. And so I took the opportunity to come over to Cato and take charge of the criminal justice effort there. And I immediately began by doing sort of informal survey of experts, try to figure out what people working in criminal justice felt was among the most fundamental problems.
Okay, guys, to receive a membership, you go to the join button. I can only do this on a computer. And you hit join, and in the top right, there are 3 dots. You click on that and it says gift membership settings. Click on that and it'll show you how to accept them. I hope that helps.
In criminal justice, and the one I think that most emerged for me is what I now describe as the practical elimination of citizen participation in our criminal justice system. The Bill of Rights devotes more words to the subject of juries than any other subject. And we have taken the centerpiece of our criminal justice system, what the framers deliberately put at the very heart of our criminal justice system, that is the citizen jury, and we've ripped it out. And I share Judge Gleason's, I've actually used the ecosystem analogy myself. I'll tease it out a little bit. Imagine you had some omnipotent power over nature, and you finally got sick of all the ants at picnics and got sick of being bitten by mosquitoes. You didn't really have any understanding of their role in the ecosystem, but you have the power to eliminate them, and so you do. But you don't understand what role they play in the ecosystem. What you would begin to see is the ecosystem would start to die. Plants would start to die, trees would be unable to reproduce, and flowers. You'd wonder why. You wouldn't know what you had done. I think that is precisely what we have done by eliminating the criminal jury from our system. Many of us are taught to believe that the primary function of a criminal jury is to
Well, my little boy has joined the stream. This isn't for children, Sonny. My boy is here. Hi, Sonny. You okay? He's with his dad tonight. Yeah, I hope you've turned it on, Susie. I'll give it another go. I'm going to run out of funds in a minute, but I will do my best to get you a membership. I don't get to choose who gets them. But I think what he is saying is so relevant here. This guy is talking about the ecosystem and removing things. So if you've got, say, you're being bitten by mosquitoes and you've got the power to get rid of mosquitoes, all you see is that I want to flick them away. I don't want them to bite me anymore. I'm going to remove them, but you don't look at the consequences. You don't look at how important they are to the ecosystem. And that is like ripping out the trial by jury. You're not looking at the big picture and the effect it's going to have on the justice system.
to assure empirically valid results, to bring in outsiders and have them test the evidence and make sure that the facts are what the government says they are. I've come to believe that may be the least important function of the criminal jury. I think that the most important function of the criminal jury in our system is to provide accountability, transparency, and oversight. And all of those things are missing from our system when citizens no longer participate on criminal juries. I also had a personal story to share very quickly. A lot of this was somewhat academic to me until I met a man who I will refer to as John. It's not his name. In a moment, you'll understand why I'm using a pseudonym. John was falsely accused by the federal government of fraud because a business that he ran in Texas went under during the financial downturn, as so many other businesses did. But this was right around the time of the Bernie Madoff Ponzi scheme up in New York, and every U.S. attorney's office in the country apparently wanted a Ponzi scalp on its wall, and so John became the target of this particular office. Long story short, they threatened John and his partner with 220 years in prison, and the plea offers, as I'm sure many of you have experienced, began cascading down. They started at 10 years, 5 years, 3 years. When they rejected 3 years, their own attorney basically screamed at them and said, "It'll never get that good." On the eve of trial, the plea offer came down to 2 years in a camp. And what I realized when John told me the story is that as the father of 2 young children, I would plead guilty to assassinating Abraham Lincoln if it got me 2 years in prison and remove the possibility of my children growing up without a father. And what that in turn made me realize is that we have gone back to a system that used to exist in medieval Europe, which is where they had judicially sanctioned torture. They absolutely had judicially sanctioned torture to extract confessions from people so that they could simplify their criminal justice process. We don't use physical torture, but we have absolutely brought that system back. And I know that because I would choose most forms of torture before I would allow myself to be separated from my children for the rest of their lives. And so I know that when my friend John was threatened with 220 years, that's the position he was in. He was effectively being threatened with torture. So I'll close by saying this. Sometimes when you come to these things as a libertarian, you sort of feel like the platypus at when people are boarding Noah's Ark. Let's see what the guy with the duckbill thinks. I think the libertarian perspective is this. Operating a criminal justice system is one of the few things that libertarians think government ought to be doing. And as I mentioned earlier, our Constitution provides more concrete guidance on that subject than any other. And if we can't get that right, if the government can't get it right, doing the one thing that governments are supposed to do in a system that is more specifically described in our Constitution than any other, what else can't the government get right? Thank you.
Thank you very much for that, Clark. We have a couple of speakers who could not be here today. My great colleague and a great partner for NACDL, Kevin Ring and the Families Against Mandatory Minimums, they had an event scheduled on the Hill and they couldn't be here. And I just want to mention that we got a wonderful statement of support from Kevin Ring, whose own experience is profiled in the report. He was, through great lawyering, saved from the ravages of the trial penalty, but not for lack of effort by those who sought to put him in jail for a geometrically increased period of time than.
Okay, guys. Yeah, Sonny's joined the chat. He's asking you to subscribe. Thank you, Sonny. But I know most of you are subs anyway, so thank you very much. I will be gifting some more memberships next live, I promise. I've reached my financial limit, I'm afraid, at the minute. But thank you all so much for being here. I don't know if you want to carry on with this. They all say much more of the same thing. So I think I will turn this video off now and we can go ahead and do some chat and let me know your thoughts. So I'm going to turn my camera back on. I will pin this video in the comment section. It seems long-winded because I had to keep stopping, but I think it says so many important things. So yeah, I'm going to finish it there. And I'll turn my camera back on. Hello. I can see you guys. Nice to see you. So what do you think? What are your thoughts on that video? Let's see. If anyone would like to come up and chat, you're more than welcome. I have to try and remember how to do this. Hey, Joanne, so great to see you. It's so nice to see you here. Yeah, I did a lot of research into this. I really did. I just wanted to, like I've said, I really wanted to look into why Brian would have perhaps taken, I'm not saying he's innocent. I believe he is. That's my opinion. I don't believe he did this because I haven't seen the evidence. And it's been frustrating me so much in all of the chats, the comments, the main channels I watch. You know, there's a lot of people out there who, like the lady from the Innocence Project said, they just want to believe that nobody who's innocent would dare to plead guilty. And that's it. That's their final stance. And it can't be that. And like we've seen here, unless it goes to trial, we're not going to have that evidence examined. And I am pretty sure that the evidence we've seen coming out since the plea deal, if that was examined, it would be thrown out. I mean, I can give you examples like I told you about the Elantra. You know, it's stock photos at the beginning. Why are they only releasing stock photos of a car? Why not the footage? Because they knew they couldn't count on the footage. That's why. The sheath is a big bone of contentment. It's really bugging me, the sheath. It's not. There's no chain of custody that's real. I'm pretty sure the ISP photos that showed it in situ, there's no date or timestamp. I didn't see any on the photos. And everything the housemates came up with initially. I remember I followed this case from the minute it was announced. And I thought 8 hours before calling 911. But what about, you know, maybe they had headphones in. Maybe they were just in their rooms. They couldn't hear it. They were asleep. It's none of the above. And it just got worse and worse and worse because they have obviously lied. The last video I put up, that had mixed opinions, but a lot of you got what I was trying to do. I was trying to show the situation, the scenario, as if the surviving roommates were male and of a different race. And would that change your way of thinking about their behavior? And I even had a comment that said something like, this person's an idiot. The surviving roommates weren't called Carlos Hernandez and Dante Bailey. They were this. What idiot puts this out? And, you know, you're just like, oh, my God, you don't get it. I'm sad you don't get it. the whole point was it was pretend. It was what if this was the case. But yeah, so I'm gonna have a look at I really need glasses now. I'm in that weird state where I need glasses to read, but long distance I don't need them, so I'm constantly doing that. So I'm going to try. So lovely to see you here. Happy Easter, everyone. Let's have a look. Let's have a look. Let's have a look. Lee's blow drying her hair. Let's see. I'm just trying to see what comments you've got. Love to know. I'm gonna yeah, pretense. That's what I think. I think I really do side eye Ann Taylor now. I had faith in her for a while, and as time went on, I felt she gave less and less and less. I think her problem, let's talk about, for example, the alternative suspects. I feel like she didn't have evidence, so she was left to deal with it at trial. You know, I'll question the witnesses and I'll bring it up that this happened and this happened and this happened. But I don't feel she could have gone to Hitler and said, okay, these are our alternative suspects because here's the proof. I don't feel there's actual proof for anyone in this case, but I do feel genuinely that there are so many red flags about other people, you could make 100 marquees out of them. You know, the surviving roommates are staggering to me. I just, the interviews by the police, they were never once treated as suspects. And, you know, I've started watching Amber Vance and she's brilliant. I love the way she presents things. Harsh sent me over there. But it's like, well, you know what? She said, because I've started back at the beginning with her videos, and one of them said she didn't see anything wrong with the 911 call and she didn't see anything wrong with Hunter Johnson. And I respect that. Absolutely respect anyone's point of view who can express it in an adult manner. But what I can't do is accept that the 911 call and Hunter Johnson were okay. I can't get that at all. I'm just trying to see, my comments aren't up to date. Hang on, let's see what we've got. Happy Easter. Oh, you got to go and eat. So does anyone want to come up? I will pin the link. Now I've got to try and remember how to do this. It's been so long, so bear with me. If anyone would like to come up and chat, I'm just going to see if that works. Right, I think I can do this. I'm going to put this in chat. Hey, I remembered how to do it. I had such a faff earlier. Oh, something weird happened there. And I think I can pin that to the top. Yeah, I'm going to pin that to the top. If anyone wants to come up and chat, I would love to hear from you. It seems I've done it twice. I agree with you, Holly Berry. I think I need to go back here. I don't know why this is not. Hang on, bear with me. I don't want to refresh. I'm not getting the latest comments. There we go. The two left alive is what got me started, beside, of course, the sad grief. Yeah, exactly. None of it's made sense. The 911 call, for example, as we all know, nobody asked for help. Not one person. Now, bear in mind, Hunter Johnson said he went up there already and told everyone to get out. He'd seen the scene. I challenge anyone to walk into that room and not run out and just sit outside and call 911. But no, not Hunter. He goes in, and from what I can understand, he goes back into the scene, grabs a knife, thinks he's, I mean, that is a shocking scene. You can tell the police who went in there, their first response was OF, OF, you know, it's a massacre. He goes in, he takes a pulse. We know from a police report, Zana was lying in a pool of red. Where's his footprints? This is crazy. And you know, the other crazy thing, when the PCA came out, there was this one latent footprint that was passing Dylan's door, which proved her story was right, that this perp was heading to the slider. But when you see the photo, that is not anybody walking past her door at all. It's somebody on the threshold of her door. It's somebody going into her room. It's on the metal grid bit. And you know, the other thing that struck me about that doorway was there was a gummy in the corner, you know, where the edge of the inside of the door would shut. She said she opened and shut that door 3 times. That gummy was intact. Wouldn't you have squished a gummy if you opened and shut the door? That's what I think. The other thing I want to bring up, and we'll do a proper live about this, is on the body cam footage on November the 13th, early morning, well, sort of midday-ish, when Captain Lanya's there, he says on body cam to his colleagues that there was a party in the house that night. And somebody even says, what, last night? Well, he said, yeah. Why are we ignoring that? He says there was a party there. He didn't mean the Friday night. He meant the Saturday night. And when the doorstep interviews took place, they're all on Lana's channel. More than one witness said they heard music playing till the early hours. Some actually even walked past the property. I think they had to go to work early or something. And they heard music playing until the early hours. So why? Look at the state of the apartment. What? How do we know there wasn't a party there? Captain Lanya said there was. They did all lie, Susie. They did. And everything was wrong. It's all wrong. The biggest question for me, just from the off, is they said they were asleep and they woke up. Initially, they said they woke up shortly before midday. And we know that's a lie because their phone records do not corroborate that. So they wake up and they call 911. Well, they call their friends over, and Hunter comes out and tells them to call 911. But on the 911 call, they don't know why they're calling. Nobody knows. Dylan actually, they say, is anyone unconscious right now? I don't know, but at 4 a.m. pretty much. So if you don't know if anyone's unconscious, let alone dead, why are you calling 911? To tell them there was a man in your house at 4 o'clock in the morning? It just does not make sense at all. Nothing about it makes sense. Hunter went into the property and found Zana and Ethan and came out and told them to call 911. How did he not convey the horror of what he saw? I don't get it. How did he not say, oh my God, don't go in there? It's horrific. How did no one mention blood? This was daylight now. This was midday. And then on the 911 call, I'm sorry, I'm laughing, but it's so ludicrous. They go back in the house and you can hear him going, Zana, Ethan, Zana, Ethan, look around you, mate. And apparently you've checked her pulse. She's been gone 8 hours. The police said rigor mortis had set in. This is it, Susie. I mean, I'm sorry. I'm very aware that projecting what we would do onto other people might not be the right way. But I truly believe this from the bottom of my heart, that if you saw that room with Xana and Ethan in. Xana had over 50 wounds and was lying in a pool of red. Why are you shouting, Xana, Ethan? And the other thing is that the door was ajar. You had to open it. How? Oh, Dylan, I don't trust you. I do not trust you one iota. How did you then, Dylan, see Xana lying on the floor if the door was partially shut? And this is a big question. I want your responses in the chat to this because I might have missed something. Dylan stated in her interview to police that when she was on her way to Bethany's room, she saw Xana lying on the floor. She had no pants on and had a grey sweatshirt on. Bethany's text to Dylan said Xana was wearing all black. Okay, so we know earlier on in the night, Xana had been wearing all black. Bethany obviously thought she was still wearing all black, which corroborates the fact that that she did not know, perhaps when Xana and Ethan got home, that Bethany was not aware that Xana had changed into a grey sweatshirt and wasn't wearing pants, just underwear. Dylan knows different. And this is a huge red flag to me. And I want to know your answers in the chat right now. How did Dylan know that Xana was lying on the floor in a grey sweatshirt? Because she saw her from the top of the stairs on her way down to Bethany. That's when she said she saw her and what she was wearing. I saw that photo where you caught sight of Xana's arm, that sweatshirt, and according to police reports, that sweatshirt was covered in red. Okay. How did she know it was grey if she was all the way back by the top of the stairs? You know, how did she know that Xana had no pants on? Okay, that might be more obvious, perhaps, from back of the stairs. Personally, I think you'd just see a shape. But Dylan says when she was on her way to Bethany's room, Xana was laying in her grey sweatshirt. First of all, she was too far away. Second of all, that sweatshirt was covered in red. And thirdly, Hunter said the door was only partially open. So either Dylan did see Xana after she got home and after Xana had got changed, and she lied about that, or she got closer to Xana than she admits. I can't think of another reason. I still want to give the benefit of the doubt as far as being a perpetrator is concerned. However, I'm very open to it, but she certainly knows things, in my opinion. I don't like that I feel that way. I don't like that I feel that way about Dylan, but there's something so wrong. You know, they're both, Dylan and Bethany have both lied. But I can't help feeling like these police interviews with Dylan and Bethany were a farce. They were just farcical. They were never treated as suspects. We know that Jack D was treated as a suspect, but he wasn't even fingerprinted till when? Months and months later. I don't feel we're ever going to get to the bottom of this case officially. There's so much wrong with it. And when the document, I braced myself for the documents, and I thought, here we go. Here we're going to see the evidence that would have come up at trial. But I still had my doubts from what Bill Thompson and the FBI said after he took the plea deal. I can't believe that Bill Thompson and whatever he was called from the FBI sat, interviewed, and said, we can't place him at the scene. We don't know that his phone was there. We can't place his phone there. They didn't, I don't believe they mentioned the car. It was just like, Well, we're relieved he took the plea deal. We're relieved about that. So we're going to accept that and move on. And we're so happy he accepted. Yeah, shocking. I couldn't believe. And when he stood up in court, Bill Thompson, after the plea, this is the case we would have put forward. I braced myself then. It's like, here we go. Let's find that piece of information that we're all waiting for. Nothing. Shocking to me. Shocking. Who's coming up to chat to me? Go on, someone be brave. Go on, somebody have a chat with me. Do you want to have a chat with me? It would be great. If not, what I will do, I want to, I'll put it in my community post. I'll put some topics up for chat. This is it. And also, you know, this all moves on to Freemasonry as well. They don't grow out of that, do they? Alumni, I don't know how to say it, but they're Freemasons as well. I brought a video out where Jack Katovich, that's another person. Where's his interview? I would love to know. I might put in the comment section of Jules or Lana, have you tried to get a FOIA for Jack Katovich, because he was with Ethan that night. There was a Venmo. He made the first payment to Ethan's GoFundMe for $6, and his sister and Molly Gray, this has always been a bone of contention for me, sent that 3:30 a.m. Venmo. It feels like they've been ignored, even though they were at the grub truck as well, obviously whispering about Kaylee. The other video I wanted to bring out, but I started digging a rabbit hole, and please understand that when I'm doing my videos that aren't lives, the last one with the AI news readers took me days. I mean, days. It was like I had to find an AI package. I didn't want to do AI, but I had a vision that I wanted fake news readers. I wanted to show perhaps how the news should have reported this case. I wasn't going to pretend to be a newsreader myself. That's why I used AI, and I'd never used it before. And also, I had to script it and make the voices say things phonetically, because otherwise it doesn't work. It took hours and hours and hours. And I started researching a video on rage kill and overkill. And you know what it's like, guys. You start going into the rabbit holes and you start digging, and I came across document after document. They're like proper, what's the word, academic documents, and you had to sift through them all and find the details. And I just dug and dug and dug and got lost. And I felt like this is going to take me weeks to really present my evidence on rage kill. But let me assure you that what I found was shocking with regards to this case. We know this. We know already, because we've got a brain cell between the lot of us, that overkill is normally personal. Partly covering up the victims with blankets is normally personal. Knife attacks are more personal than gun attacks. And damage to the face, to the extent Kaylee received, is incredibly personal. And it's all been ignored, all of it. So let's meet again. Sunday nights are probably the best for me. I am actually away with my boy next week. I was going to fill you in on a little bit about my life since I've seen you all. A lot has changed. As many of you know, I was caring for my brother, and bless his heart, he has been in hospital since September. He has kidney disease, which has got worse, and vascular disease in his leg, which is always getting infections. So bless his heart, he will have to have more care now than I'm able to offer him. So that's been a shift in my life, and I've now got a job. It's part-time, but it means that I can trying to see the positive in what's going on. I did my counselling course. I finished that. I did my level 3 counselling studies, which was great. Sadly, to do level 4, I need £8,000, which isn't going to happen right now, but it was great. It was a fantastic course and taught me so much about myself and how we behave as humans. I might go on to do a forensic psychology course, but we'll see. Watch the space there. But I've got myself a part-time job, which means I've got more money coming in, and I get, because I work for a school, I get all the school holidays off. So I've got more time to dedicate to this. I've got all the time I need to dedicate to my son, and I can afford to go away now and again, which we couldn't for a while. So I'm going to London, UK. I'm UK anyway, but I'm in Wales, which seems like the end of the world. So I'm going to London this week for a tour. I used to live there, and now I'm going back as a tourist with my son. So that's going to be fun. But I will be back on Saturday. So I would like to do a live on Sunday again. And someone come up with me. Someone come on panel and have a chat and tell me your thoughts. I'd love to discuss, if you would, Frats versus Cartel versus Brian. And I want to say this as the end of my live. First of all, thank you all for being here. Secondly, every opinion is welcome. If you believe Brian did this, you are welcome. I'm open to that still, but as I said, I haven't seen the evidence. But say it with respect, please. I've had to take a step back from all of this, and I got very emotional about things in this case and how people treat each other, and I got wrapped up in all of it. I've come back determined not to get involved in any of that, the trolls and the bitching and the nastiness, and I was very passionate about all that before, and it would really get to me, and I'm not allowing that to happen again. So I'm going to be blocking anybody who can't speak to others with respect and have a debate like a grown-up, because we're beyond that. Surely we can talk to each other. I've had some nice discussions with people who believe Brian's guilty, and I respect that 100%, but I will not tolerate people who just name call and call each other ridiculous names because they've got a difference of opinion. I can't do that, and it makes my blood pressure hit sky high. So we've all got to look after ourselves in this community. It's a sensitive community. Let's talk to each other with respect, and I know a lot of us can do that. So thank you all so much for being here. I hope that video, I know it was very long-winded in a way, but the documents I found that backed what they were saying were even more long-winded. So I got back to that video, and it had some really important points, I think, about what's going on in the justice system. Plea deals are going on everywhere. They prefer it to a trial. It means that evidence can't be examined. Illegally obtained evidence can't be questioned. And it's the plea deal, an offer that they can't refuse. And if we put ourselves in Brian's position, I know what I would do. I'd want to save my life, because there would always be a part of me that thought, you know what, maybe I can still prove this. Maybe justice will be done in the end. I can't do that if I'm dead. And that is my final thought of it. So thank you so much for being here, guys. Take care. Happy Easter. Let's do it next Sunday. Lots of love. I'm going to go now. Bye-bye.